Hello, this is Jed Brewer with Below the Line Club and Study Groups, and it's very nice to have you on the call today. Thank you for taking the time to be here. I'm really pleased that we've got some exciting guests to talk about ways that we can limit personal risk. And have a couple people I'd like to introduce here quickly. One of our partners that'll be on here is Jim Dierking with Winthrop and Weinstein, which is a law firm in Minneapolis. And Jim is a partner in that company, and he'll be speaking with one of his partners, Tammy Dean. And they're really a full-service law firm. They have about 150 lawyers, do all varieties of commercial law. But Jim and Tammy are focused specifically on our industry and the work that they do. So a lot of work in finance, M&A, contracts, environmental, and they are going to do a deep dive for us into areas that we have personal risk as it relates to piercing the corporate veil, and also in fiduciary responsibilities that we may have. But I mean, I think a big issue that we want to communicate on this webinar here is, as leaders of our organization, whether a firm owner or maybe even a key manager, knowingly or unknowingly, there may be areas that we open ourselves up to personal liability, and we need to be aware of those things, and then what we can do as fiduciaries, one, to avoid a claim arising against us and mitigate that risk that we have. So it should be very informative. And then the second person or presenter that we will have is Gus Hong, who's the CEO and co-founder of Alexandria Capital. Alexandria Capital is a financial services company based out of Washington, D.C., and then also has an office in New York and a couple other offices. But Gus really specializes in a full suite of financial services, one of which is offering 401ks and managing those plans. So Gus will do a deep dive into us, specifically addressed to 401ks and areas that we have fiduciary and potential personal liability in that aspect. So without further ado, Jim and Tammy at Winthrop and Weinstein, I am going to turn the floor over to you to dive into piercing the corporate veil. But first of all, for our audience, we will make these slides available to you, so you have them after the call as well as a recording of the call. I have you presently on mute, but we want to make sure your questions are answered. So if you have a question, please type it into the GoToWebinar framework, and I will be able to see those questions, and I can then relay them on to our presenters at the appropriate time. So we want this to be as interactive as possible. Please take the opportunity to ask any questions that you have. So Tammy, Jim, let me turn the floor over to you.
Great.
Thank you, Jed. Appreciate you having us on the call here today and the opportunity to speak to the group, and welcome to everyone who's listening. We look forward to questions at the end or from Jed perhaps along the way. As Jed mentioned, we are going to be talking today about different ways to protect the company assets and to limit personal risk. We have three kind of topic headings, I guess, for our discussion today. As Jed mentioned, one will be piercing the corporate veil. We'll talk about how and when those situations can come up and how to protect against it. Personal guarantees, which is obviously something that you'll know you're undertaking that risk before you do it, but we'll talk about ways to potentially try and limit your exposure there. And then the third bullet point is kind of corporate fiduciary obligations and how those can, under certain circumstances, turn into potential personal exposure. Before we dive into that, real quickly, Jed kind of highlighted ourselves and our firm. We are, as he mentioned, a Minneapolis law firm with about 150 lawyers. We cover really the waterfront of any and all business issues, large businesses to small businesses, startups, all along the way. And we have, 10 or 15 kind of departments or groups within the firm that specialize in various areas that our clients need. Also, as Jed mentioned, Tammy and I are focused on this particular industry, and we represent a number of businesses that are in the retail side or the fuel distribution side, or other participants in the industry. So we've had a chance as members of the Below the Line Club to talk to a couple of different groups over the past year, and appreciate the chance again today and look forward to walking through these issues. So I'll get started here. As I mentioned, the first bullet point, or the first topic we want to cover, is piercing the corporate veil. And as you probably all are aware, corporations and limited liability companies and certain types of partnerships as well come with kind of a separateness to them. They are recognized under the law as a separate legal entity with its own assets, liabilities, and exposures, separate and apart from the owners of that company, the individuals that are running the show. So with that comes generally a shield between the company, the entity, and the individuals, so that individuals generally are not on the hook for the company's debts, liabilities, and obligations. And courts around the country, while there are some nuances and small differences from state to state and court to court, generally that shield and that separateness is recognized by the courts. So that's kind of the starting point, and that's one of the main reasons that people kind of form companies in the first place, is to get the advantage of that shield. Under some situations that we'll dive into a little more deeply, claims can come up where a third party is claiming that the owners of the company in particular, perhaps the directors under some situations, should be liable and should be exposed for what is otherwise a company debt, liability, or obligation. For example, you may have an injury or significant damage arising from the business operations that isn't covered by insurance, and or it might be well above the amounts, the limits on the company's insurance. And if it's not covered by insurance and the company's assets, you may find a claim by the plaintiff in an action against the company. You may find a claim also against the owners and the individuals, claiming that they ought to be held liable. Another sort of general situation where this can come up is just general insolvency situations, where a company is insolvent and is not able to pay its creditors generally as the claims come up. So either of those situations can result in a lawsuit against the company and the owners. So when a court is faced with a claim like that the owners ought to be liable for a company obligation, they are trying to determine whether the separateness of the company should be honored or if the individual owners should be liable themselves. A couple of prongs that most of the courts generally look at is, number one, did the company itself honor that separateness, or were the lines blurred with the individual owners? And a second prong is whether there would be an inequitable result if the corporate veil was not pierced. So the first prong there, did the company itself honor the separateness, or were the lines blurred? There are some things diving deeper that the courts have looked at to make that kind of determination. First of all, was the company properly capitalized, either at the inception of the company when it was started or at the time of any kind of major recapitalization? And they will look there at what was the intended business purpose or the plan at the beginning. So when the company is set up, they'll take a look at what the plan was for the business, what was the company planning to do, and was it capitalized appropriately for that. We'll get into a couple examples later where courts have pierced the corporate veil, and this was really a major factor for them. Now, this doesn't mean that you have to kind of guess right as to how the future is going to go when you're capitalizing the company up front. It's more about were reasonable choices made and reasonable decisions made at the time of capitalizing the entity, and were those decisions and the amount of capital appropriate for the situation at the time, and did they connect with what the business plan was. A second factor then that a court would look at here is, were the business assets or property used by the owners for personal purposes? And this is where oftentimes, especially with small companies or startups, lines can be really blurry. So for example, if a company car, a car purchased and owned by the company is used for personal purposes, or the company buys perhaps a personal computer that's used just for personal purposes, or even phones. Generally, the theme there is company property purchased by the company being used by the individuals for their own kind of individual personal purposes. Now, this is something that at different levels I think happens very frequently. So it's not like if the company buys you a phone or a car and you happen to run to the grocery store or make some personal calls, it's not like you are automatically exposed for personal liability for everything the company has for its debts and obligations. Overall, these analyses by the court are kind of facts and circumstances, and they're going to look at a number of different things and weigh them into the equation. So this is not sort of an automatic by any stretch, but really what's important here, and the best way to protect yourself, is to document and treat these kinds of things appropriately. So for example, it might be a better idea to have the individuals purchase the phone, purchase the computer, purchase the car, or to allocate time spent and document that on each, so that you can kind of divide it up, the expense of it, divide it up between a personal expense and a company expense. Or if the company is going to buy property that's going to be used individually, you can also look to treat those types of things as additional compensation to the employee, so that they then pay taxes on it, and it then is sort of treated more like personal individual property. Okay, a third factor that the court is looking at here when they're trying to assess the separateness is whether the company itself followed applicable statutory requirements. So every state has different but pretty similar requirements for a corporation or an LLC, for example, that when those entities are formed, the statutes will require the company to take certain steps. For example, shareholder and director meetings, keeping company records and financial records, and having business decisions made by the directors and or the officers of the company. And really what's important here is documentation. So the more that you can clearly document that meetings were held and business matters were discussed, and whether it's a shareholder meeting or a director meeting or whatever it is, that it's the decisions made at the meeting for the business are documented in some kind of minutes of the meeting or resolutions that the board or the shareholders take at the meeting. And really, the more that is documented from a practical perspective, the more protection you're going to have here to show that, yes, this company acted like a separate entity and took the steps that are required under the applicable statutes to show that it is to act like a corporation or an LLC.
Jim, Jed here.
Yeah.
Can you give an example of something that would give rise to a claim like this that would pierce the corporate veil? That maybe somebody in our industry.
Yeah. So Yes. I think really sort of the catastrophic event that's not going to be covered by insurance or the company's assets is the best example here probably. And for the folks on the phone here, maybe a lot of you are in, or some of you are in the fuel distribution business. You may have a trucking company that goes along with the business. And it's really the catastrophic accident, people are killed, property is damaged, that kind of thing, where especially if there's, the more kinds of potential plaintiffs on the other end, the more likely. So if you have a catastrophic accident where, 2 or 3 people are killed or significantly injured, a lot of property damage, you're likely to have a lot of different people coming at you with big claims. And it's those types of situations where if those claims aren't going to be satisfied from, just a judgment against the company covered by insurance and or covered by the company's assets, then they're going to start poking around and try and find someone else to pay up. So they're at least going to put, those are the situations where this is likely to come up. And what they do then is they just name the owners and they'll start digging around in discovery mode, looking to see if there is anything about the way the company acted, the way it was set up, the way its finances were handled, that might give them a claim to pierce the veil and stick liability onto the personal owners, the individual owners. That's probably the best example I can think of.
And do they just have to find one loophole, potential area that the company misstepped, or does the company need to be pretty egregious in negligence or so forth for it to be a successful lawsuit by the plaintiffs?
Yeah, it is generally not just find one loophole. It's a lot of different facts and circumstances that the court will look at, and I'd say, most of the cases are going to come out on the more egregious side before they're going to pierce the veil. You will find, again, a lot of differences from court to court and state to state, but generally speaking, it's not the, oops, we tripped up in one area and now we're stuck. It seems that most courts have, in terms of kind of what are the most important factors, I think it's the capitalization factor, whether the company was appropriately capitalized. And then it's, company finances. How blurry is the line between the company's money and assets versus the individual's money and assets? Those are, I think, the 2 biggest factors that you'll see. But, any good aggressive plaintiff's lawyer is going to try to latch on to anything and everything they can find in discovery just to try and put the squeeze on, and if nothing else, get some kind of settlement out of the individuals.
Yeah, and that's interesting about the commingling of expenses and so forth, because we're private companies, and by design, we try to run as much through the company as we can justify for tax purposes. And
no doubt about that. Yeah. And I think really what's important there is to be thoughtful about each of those items that are being kind of run through the company and to document them appropriately. One thing that can come up in that regard is kind of personal loans made by owners into the company and how those are documented and treated. If they are described generally as loans, but they're treated more like equity, then it can just sort of, again, look more like, or the other way around, frankly, if they're described, I'm putting this money in as additional equity, but then the company is making, let's say the company is making interest payments. There's a disconnect there between the equity and interest payments, and so that really starts to look like a loan. So it's, the more clear and consistent you can be in your documentation, the less hooks you're going to provide to the plaintiff's attorneys who are going to try and knock the whole thing down.
That makes sense.
Okay, so those are really the highlights for the first prong of the court analysis. And again, just to circle back, that was whether or not the company honored the separateness or were the lines blurred. The second prong is whether there would be an inequitable result if they did not pierce the veil. And that's not just about, court's not just going to look at the situation and say, well, these 6 people were killed or seriously injured, and I want to make sure we take care of them, so I'll do whatever I need to do. It's not that kind of analysis at all, but they will look at the conduct of the owners and the shareholders vis-a-vis the company in determining whether it would be inequitable to provide the owners with the shield that they would normally have. So this is really more about the court looking for improper motive, whether the company was really a sham, again, the insufficient capitalization, was there actual fraud or a wrongful purpose to begin with, or through the conduct of the business. So it's really more about bad conduct or conduct that is just clearly not about treating the company as a separate entity. So they will weigh that then, that if the court finds those facts and finds that that kind of conduct occurred, they'll weigh that against the alleged injury and the circumstances, and just is making sure that there was a connection between the two. So a couple of quick examples here. There was a case not long ago in Alabama where plaintiffs were successful in piercing the veil of a construction company, and these plaintiffs, I think, were just kind of creditors who had remained unpaid by the company. And it was a construction company that was not capitalized at all. It was set up by 1 or 2 people with zero money, and the owners used the company bank account for personal purchases. Fairly egregious across the board. They really sort of failed at all stages of the analysis and had not capitalized the company, treated it as a separate entity, or treated its finances separately. And the individual owners there were held liable for the obligations that were otherwise company obligations. And then an Iowa case, I think a fairly similar situation where the plaintiffs were unpaid creditors. And this was an egg hatching and chicken growing business that was, again, undercapitalized at inception. Then along the way, as they were buying eggs from suppliers, they had made misrepresentations to the supplier that 1 or 2 of their related affiliated entities who actually did have nice financial statements, they misrepresented that those entities were backing this particular company, which did not turn out to be the case. And this company kept on accepting product from its suppliers while knowing they didn't have the money to pay. And so the court pierced the veil in that case and found that the individual owners were also exposed there.
So Jim,
yeah.
Is there a way as a firm to figure out if you're okay or if you're not okay? I mean, in terms of commingling of the expenses and running stuff through like a mock audit, so to speak, or what can somebody do if they have questions about am I compliant or not?
Yeah, I think it's probably a 2-pronged thing that what I would recommend is more of a almost forensic audit of both your corporate records and your financial records. And so, you know, a CPA or an accounting firm, on the one hand, kind of just looking at how personal expenses are handled through the company's books would go a long way, I think. And I would, you know, be very clear with the folks doing that audit that this is the purpose. You know, this is why this is what you want them to look at, and why you want them to look is to make sure that they are not that the company's not treating things inappropriately in terms of expenses between the owners and the company. And then a corporate audit, really to sort of look at the company's books and records, their minutes, Are they kept up? Are they regular? Is there a regular meeting at least once a year of the shareholders and or the directors? And how are those things being documented? Just to see if there are additional steps that can be taken. Where that can get a little bit more complicated, and this segues into I think the last point that I was going to make on this piece, is a lot of companies will maybe have some retail operations and some fuel distribution operations, and again, perhaps some trucking operations, and maybe, some real estate holding entities. So the overall organizational structure looks like 3 or 4 maybe separate sister companies, possibly with the same ownership at the top, possibly with a little bit different ownership here and there. Sometimes we'll see, some family members are involved on just the real estate holding side, whereas other family members are involved in other aspects of the business. So it may be that you have different ownership at the top. But the point I'm getting to is that even in that structure where there are multiple entities, the whole piercing the veil concept can still apply. And one entity in the structure could end up being found liable for the obligations of another entity in the structure if the separateness of those various entities, in the same manner as we've talked about so far, is not respected and documented. So now, Jed, I forgot what led me into that, but I just wanted to make sure that we touched on that too, that the most simple structure is one company with 1 or 2 owners. But these concepts can apply as well in a more complex organizational structure as well.
And I think the question about how to make sure that you're complying, or is there anything you can do, as Jim said, you can do a financial audit, and it also makes sense to do a legal audit and have someone take a look at that organizational structure and make sure that you have appropriate things in place to avoid the liability.
Right, exactly. Thanks, Tammy. And along those lines, a lot of companies that may have that kind of more complex structure, it's really, when it comes down to it, let's just say 1 or 2 people who are essentially running the overall organization. So maybe they are on the board of directors of every company and have some ownership stake of every company. And so it can get a little confusing probably to think about which corporate hat do I have on right now. But the more that you can, and you don't have to, it's not like every step of the way through your day you have to be sort of thinking about your organizational structure and who am I representing now. But having that in the back of your mind at some points along the way is a good idea, just to maintain the whole separateness thing. We've talked in to other groups about there are some things when you've got an organizational structure like that makes sense to have consolidated in one spot. Admin stuff, HR stuff, insurance stuff. It may make sense to consolidate that and have sort of one of the companies handle it for the rest. And that's all fine, and it's all well and good, and that doesn't blow up your shield. It's really about documenting it, charging each entity for their appropriate share, and that kind of thing.
Mm-hmm. So is it fair to say, Jim, just as we wrap this up on the corporate veil, that it's pierced relatively infrequently, but when it's pierced, it tends to be sizable in damages?
Yeah, I think that's a fair statement. Yep. Yeah. Yep. And it isn't really hard to take the right steps to avoid it. It's just about being mindful of it and having the right advisors involved that can help you navigate that. It's not a really difficult thing to do.
Good, thank you. And I believe just in the next couple minutes here, you've got a couple other umbrella areas you discussed too.
We do, and we might blow pretty quickly through the guarantee portion. I'll let Tammy talk a little bit more about the general corporate fiduciary issues.
So as Jim has talked about, most of the time when you're operating a company, you're looking for ways to limit your personal liability and to keep the liability with the company itself. But sometimes we voluntarily agree to take on the personal risk, and we usually do this through a personal guarantee. So personal guarantee is really a promise or an agreement to make yourself personally liable for a debt or some other obligation of the company. This could come up under a lease agreement or some other type of contract. If you personally guarantee the debt of your company or some other obligation, that means that the lender or the other party to your contract can come after the assets that are owned not only by the business, but they can also come after your personal assets if you default under that loan or your other contractual obligations. So why would anyone do this? Often in a business context, you really have no choice. If you have a new company or even a new business relationship, the lender or the other party to the contract may require that one or more of the owners essentially co-sign for the obligations that are being agreed to. From a practical perspective, sometimes our clients misunderstand this and think that just by guaranteeing something, their guarantee can only be called if there's some sort of inability of the company itself to satisfy the obligations. And while that's part in true that the guarantee doesn't come into play unless there's a default, once there is a default, the lender or the other party to the contract can come after the guarantor's assets typically at any time. So how do you avoid this, or what do you do to limit your exposure in these cases? It's really many times tough to avoid completely. In a lease arrangement or some other type of contract arrangement, you can often offer to show financial statements, or if it's a lease, you could offer to pay a higher security deposit to avoid that personal guarantee. But really, if you're required to give a personal guarantee, we like to tell our clients that they should think about strategies to limit the risk. So if you can't avoid it completely, at least try to limit it. Sometimes you can restrict the amount or the duration of that guarantee. So instead of guaranteeing all of the obligations between the two parties, just guarantee one particular obligation, maybe this particular loan, not all future loans that you may receive from that lender. In a real estate context particularly, you can often negotiate a provision that says if your payment history remains strong, the guarantee will burn off over time, or that it will be limited to a total amount. Two additional points we want to make about personal guarantees are that, first, if there's multiple guarantors, consider making an agreement amongst the guarantors for contribution if there is a default. As I mentioned earlier, if a lender or someone else comes after a guarantor, they can typically come after that guarantor for all of the amount that's due. And if you have 3 or 4 people who are guaranteeing that loan, it often seems unfair to our clients that one person can be held responsible for the entire amount. So you can avoid that kind of unfair result by having an agreement in place behind the scenes, so to speak, amongst the various guarantors. And then the second piece of practical advice that we like to tell people is don't forget about the guarantee. We sometimes have our clients come to us and they've either exited a company or they've sold their portion of the company. But if you've signed a personal guarantee, that's a personal obligation that stays with you. So just because you're no longer affiliated with the company, it doesn't mean that that guarantee goes away. So if you are considering an exit strategy and there are personal guarantees, make sure that you find a substitute guarantor or that you find a way to protect yourself from potential future liability. And then very quick, since we want to make sure we're leaving enough time for Gus to cover his topics, the third topic that we have really ties in fairly closely to what Jim talked about in his first section, and that's just the corporate fiduciary duties. As directors of a company, you have certain fiduciary duties or obligations that you owe to the company. And the reason this is important is because if you don't honor these duties, you could, in some circumstances, be held personally liable for mistakes that are made by the company. These duties are often referred to as the duty of care, the duty of good faith, and the duty of loyalty. And we could give an entire webinar, I think, on what those duties are. So I'll just say that you need to remember that you have to exercise good business judgment, use ordinary care and prudence in the operation of your business, make sure that you're always acting in the best interest of the company and not yourself, and that you're putting the company's interests first. If you do these things and you make sure that you are keeping in mind, as Jim said, which hat you're wearing when you're making decisions, you should be able to avoid personal liability.
So Tammy, let's suppose I'm a vice president of a company and I do something negligent as the vice president, a suit comes and ultimately I'm found to be at fault. And if the company has directors and officers insurance, does that pay my personal responsibility, or am I still, as the vice president, responsible for my actions personally?
That's a good question, but a complicated question, because it would depend on a number of factors. First of all, directors and officers insurance is an excellent strategy for companies to have, and most sophisticated directors will insist that the company carry that to offer some level of protection. But those policies can differ, and it will depend in part on whether that negligent act was a criminal act or just something that was maybe not the best decision. There is a concept that we have up on the slide called the business judgment rule. And this says that if business decisions are being made by informed, disinterested persons who are operating under a good faith belief that the decision will actually serve the corporation's best interest, you're afforded a higher level of protection. So unfortunately, it's not a simple yes or no answer to your question, but D&O insurance is a good strategy for limiting exposure so long as it's not a criminal act.
Got it. Well, good. Thank you guys for that high-level overview of these three buckets. The corporate veil was a big one that you talked about, as well as the fiduciary duties. And I want to turn now over to Gus, because Gus is going to talk quite a bit more detail about some well-meaning plans that we as employers put together for the benefit of our employees, and can give rise to potential personal liability too. So, Gus, I'm going to flip this over and make you the presenter so we can see your beautiful mugshot.
Can you all hear me okay though?
Yeah, you sound great.
Okay. Let me know which screen do you see.
401k plan danger.
Okay. So I get to continue on the theme about, personal risk and how we can manage our risk in the context of all these things that are going on. Now, particular to 401k, what's interesting with 401k is that, unlike, what we had just previously talked about, fiduciary liability, responsibilities. Very often, people that are part of managing this 401k or 401k-like plans often don't even realize that they are fiduciaries. And I think that is really the start of what is so dangerous about this. So let's begin with the law. Most people refer to this law as the ERISA. It stands for the Employee Retirement Income Security Act of 1974. It's a federal law that sets a minimum standards for most voluntarily established plans, specifically retirement and health plans, and it is for private industries to provide protection for individuals, quote and unquote, the participants in these plans. And how does this relate to our topic today, specifically, and according to a section in ERISA? And I'm going to sort of quickly read this off to you. Any person who is a fiduciary with respect to a plan who breaches any of the responsibilities, obligations, or duties imposed upon fiduciaries by this title shall be personally liable. Now, this is something most 401k plan providers, sponsors, very often business owners are not aware of. So again, part of our discussion today is to truly give some insight into what this is, the motivation for this, and what we can do to plan and manage against this exposure. I have a couple of quotes from a well-known publication that speaks to this a little bit. The second one, because we don't have to go through everything, but in the Entrepreneur magazine, June 2017, they state that building and growing a company requires intense dedication, and especially the small firms don't have the time to studiously manage and monitor a 401k plan. They simply trust the broker who sold them the plan and assume that because they're nice that the plan is working as sold. Now, okay, we're missing the end quotes there.
That sounds like the case in my plan, Gus.
I have to tell you, this is what most people sort of defer to. We, certainly have had many opportunities to speak to plan providers, and they all think that just because they have this guy from Fidelity, Principal, that they're handling all these responsibilities on their behalf. And in fact, a lot of the HR folks, and we can refer to the quote above, think that just because they're working for a company and that they have bosses in this organizational structure, that they're personally now responsible for what goes on in 401k plans. But again, this is a quote from Forbes article. The vast majority of HR representatives likely have no idea of the significant liability they're exposed to in their duties regarding their company's 401k. Turning a blind eye or missing a small detail may result in significant legal consequences and personal liability, potentially exposing their personal asset. And there are many pending litigations that speaks to this. And the following graph will also tell you the increase in complaints, 401k complaints. So if you look at the charts, you'll find that 2016 and 17, their combined complaints probably are the most since the 2008 and 9. And we all know what happened in 2008 and 9. So before we look at some additional data on 401k litigation, let's again,
Let me dive into this graph just a little bit, because the recession period of 2008 and 9 is very interesting, where you see this spike in complaints. We may be on the border of another recession at some point. Maybe it's this year, maybe it's 10 years, who knows, but at some point we're going to see one. What's the driving factor to cause this increase in complaints during a recession? Is it people are short on money, so they're saying, hey, let me file this lawsuit, maybe I can get some that way? Any insight you can provide?
Yeah, for years 2008 and 2009, the biggest reason for the suit was folks thinking that the investment choices that they were offered were inappropriate. So it deals with investments and investment choices.
Got it.
Whereas,
so down market, as
naturally,
people say, gosh, I just lost X percent. Of course, it's a risk-based portfolio, but they don't like losses. Yeah.
Correct. And we're going to touch on the reasons for why people sue, because it's important to know that, again, if I'm the sponsor or fiduciary to a plan, I need to know why people are suing me so that I can guard against it. In 2016 and 17, the driving or the largest, cause is a little bit different. During those years, the biggest complaint was in reference to the fees they were charged. So give me a second, we'll get to those slides, but let's first define. So how does let's say the agency that's sort of enforcing ERISA, define fiduciary or who they deem to be fiduciaries. And the Department of Labor defines fiduciaries as any person or even entities with discretionary authority over the management of the plan. They can include plan trustees, plan sponsor, plan administrators, member of the plan's investment committee. So in other words, fiduciary for most plans include the owner executives, and in some cases, the head of the accounting or the human resource departments, or any intermediaries that help sort of coordinate the 401k plan for the company. So that's a pretty wide definition. So if you think that you have any involvement in overseeing your company's 401k plan, speak to somebody, speak to your bosses, speak to the CEO. And in many cases, if it's a well thought out and documented 401k plan, we can have people specifically defined, to do X, Y, Z and to be deemed fiduciaries, and people that are just following orders and administratively without discretion being involved in the plan, for their responsibilities to be explicitly defined somewhere in the document or in the overall 401k plan management, so that there's no confusion as to whether you're a fiduciary or not. Then let's talk about then, what should they be worried about? And we were just alluding to some of the reasons why people sue, and that is really it. Lawsuits being brought to the plan sponsors, and typically when a lawsuit is filed, they try to name as many responsible parties as they can. And at times it could be overreaching, but that's just the way, reality pans out though. So we're going to be talking about things to defend against your personal exposure, personal risk, but let's quickly identify the main causes for lawsuits. And they are three factors, three causes, sort of dominate that space. And the three reasons, again, first one, let me just go back to the earlier slide. First one is inappropriate investment choices, naturally, and we briefly talked about that, and that being the largest reason in 2008 and 9. If you see the graph with gray, that is the inappropriate investment choices. A little burgundy is excessive fees, and the I think dark blue or black is self-dealing. So there's a contrast here from 2008 and 9 versus 2016 and 17. And as more and more folks are learning about how a lot of the investments that they get to invest in have fees that they never knew about, and ERISA is mandating folks for proper fee disclosure and that information being shared with the participants, people are a lot more weary about what they're paying for the investments that they're getting. We can go through each item, but I see that we're running into a little time management issues. So I can tell you, if you like to spend a little bit more time learning about what it is that you need to do to measure against inappropriate investment choices and guard against these causes, I can speak to you sort of offline as well. But just quickly, we need to ensure that, or the plans should afford the participants the ability to be able to choose among number of different investments, so that they can develop a proper diversification. And while ERISA doesn't tell you exactly what to invest, they will tell you that the process through which investment choices are made available to the participants should be managed with care, prudence, skill, diligence, that a prudent man would choose or would sort of manage when choosing investments. Very consistent with, I think, what Tammy brought up earlier about ensuring that whatever it is that you're doing, you really need to look out for the benefit of the plan participants, because they're ultimately the beneficiaries of all the work that you're doing.
So, Gus, if I took all of the plan assets and I stuck it in a single illiquid real estate project, would that potentially give rise to not being a good fiduciary?
Absolutely. Again, ERISA is going to mandate that you apply what they call prudent man theory. What would a prudent man do in that position? And what would he or she do to ensure that there's no great loss in investment? So you got one single investment and risky asset class. I think that may qualify as being something unusually risky and may not be appropriate.
Gus, a question that came in from an audience member just says, would a 338 fiduciary, and you'll have to explain to me, an ignorant man, what a 338 fiduciary is, but take all the risk of selecting the investment options, thus eliminating ownership liability?
So if you're a fiduciary, let's just say, you're the owner of the business and you set this plan up for your employees, and you just don't have the time or the ability to put together the right investment selections for your program, what you can do is hire a third-party vendor. And if that vendor happens to be either a bank, insurance company, or what they call registered investment advisor, then they often can serve as a 338 advisor. And what you're doing is essentially transferring your fiduciary liability or the exposure of managing the investments to that third party 338 manager. But having said that, it doesn't eliminate your fiduciary duty to ensure that you have a system in place to continue to monitor the effectiveness and the ability of that 338 advisor. So as an example, if an investment, goes wrong and people are unhappy about it and they bring a suit, then 338 will help in that scenario. But 338 may not help you if 338 was negligent, did not uphold his or her fiduciary duties, and you as a plan sponsor did nothing to periodically review their performance.
So we still have oversight responsibility over that 338.
Absolutely. And there is a 321 investment advisor. They're not actively and independent of the fiduciary of the plan managing the underlying investments. So they sort of play a co-fiduciary duty with the plan sponsors, but the transfer of the liability isn't eliminated, or the risk is not eliminated by hiring 321 alone. I also mentioned that the banks and insurance companies and registered investment advisors are the only entities that can be a 338 advisor. But keep in mind, many of the insurance companies and most plan sponsors come across, they're not positioned as a 338 advisor, rather just as a sales organization and a service vendor that is providing the product for the investments And if you ask them whether they would also serve as a 338 fiduciary advisor to the plan, they would say no. Or they would recommend that you hire another party to be included in your 401k management, because to be a 338 manager as an insurance company, and then is to function in a totally different regulated environment where their profitability cannot always be, the most important thing. And the insurance companies that provide the products, typically, their motive isn't to be a fiduciary, but rather to maximize their profitability. And banks stay away from that altogether. So it's rare that you will ever see a bank playing a 338 role. And insurance companies rarely do that, because, to be a fiduciary is to then minimize their priority to maximizing their profitability.
So Gus, thank you. One of the other items you brought up, you're flipping to it, excessive fees here. I mean, just think of myself as a plan participant. Any fee I pay is excessive, it feels like. So can you elaborate a little bit on what it means to be an excessive fee?
Well, I don't even think most people understand how much they're paying. So I think that's the first starting point, and especially for the smaller business owners, in order to sort of simplify the whole 401k offering process, they hire a broker, mutual fund company, or insurance company with bundled services. In many cases nowadays, they buy 401k plans through their payroll company because it's simple and everything is integrated. So look, if you're focused on building your own company and doing what you need to do to become viable, spending any amount of your time in things other than building profitability, again, it's work, and it's something that you want to offload. And the payroll company, insurance companies, mutual fund companies with bundle services, it's very hard to understand what you're paying, but all plans will, again, their fees will be broken into two main groups: fees relating to the cost of managing your investments, and administrative fees for record keeping and ensuring the communication, operation, documentation, and that's under the whole, set of fees that you need to look at. So very often when we walk into a prospect with a existing plan, first thing we do is we run a cost comparison or cost analysis to ensure that a lot of the fees that they may, not even have known about are all disclosed. And, given, the recent regulatory changes where there's a real mandate from ERISA to all these service providers to disclose the fees and make the fee and the understanding of the fee structure a little bit more coherent for lay people. They have different disclosure requirements. There's a statement called 408B2 that's got to be issued to the plan sponsors so that they can understand what they're paying for. And even that, when they look at it, most sponsors can't decipher what the numbers are. And they're responsible for, in turn, taking the information from there and creating that disclosure, the communication tool for their plan participants that is a requirement to be in compliance with ERISA. And very often that communication to the plan participants via what they call 404A isn't done regularly. So there's just a lot of information I'm sharing with you folks, but given, limited time to sort of convey or communicate all this to you, I apologize. Again, we can have an offline follow-up conversation for those people that want greater and deeper dive into the requirements, fiduciary responsibilities. And the last cause is really self-dealing. And best example for that is, there are pending lawsuits with Charles Schwab, Principal, Morgan Stanley, where their employees were offered, investments in 401k plan that they were managing, and these investments that they were managing didn't necessarily have the best performance potential. They even had excessive fees. And in some cases, the firms added their newest funds before these options had established any suitable and credible performance track record. So that's not in the best interest of the participants. It's self-dealing. What they're doing is putting their interest above and ahead of the plan participants. So the last slide talks about, and I've outlined 6 points, quick points to play defense. So how do you defend against all this? And the overriding factor is prudence. So first thing is get familiar with your fiduciary duties. And I think that's the first thing, and really know whether you're a fiduciary. Everything that you're trying to do for your employees, document the process that you're using to carry out your duties. Give participants, and we talked about this briefly, the ability to choose from a broad range of investment opportunities. Number 4, consider hiring a service provider to handle fiduciary functions. 338 investment advisor, 321 investment advisor. Actually, 330 is investment manager. And I had written an article for BTL last quarter, and there's going to be a follow-up this quarter as well about 401k and risk and fiduciary responsibilities. In our earlier article, we advise people to perform mock audits just periodically. It may not have to be every year, but do it every other year if you can't. And try to see what the audit produces. And what you want to do is understand how your fees compare to sort of the industry average, and how you're offering investments and what guidelines you're using to identify and develop investment choices for your clients. And there's real documentation that's got to follow, and whether you're keeping these documentation in a correct manner, or whether you're even documenting some of the more important things you should be documenting. And the last point is, you can always consider fiduciary liability policy. This is a little different than a fiduciary bond that is a requirement for most 401k plans. This is really to cover any litigation claims or pay for legal fees, largely defending against claims, as well as financial losses from the plan incurred sort of due to errors, omission, or breach of fiduciary duty. So I ran through this really quick. I know we ran out of time, but that's all for me on my end.
Well, thank you, Gus. And I assume this is similar to what we saw with piercing the corporate veil, that these lawsuits, they tend to happen relatively infrequently, but when they do, are they fairly sizable in nature?
I think so, but forget the lawsuits. I think what's happening now, DOL is becoming a little bit more aggressive in regulating or just bringing, issues with the companies themselves. So whether it's to be fine,
you don't necessarily have to have a disgruntled participant. It can be pushed on from the outside in, from a third party like the government.
Yes, and that I think DOL is getting a little busier with regulating and enforcing the ERISA law.
And then you mentioned the mock audit. What is the best kind of company, or how do you do the mock audit? Do you employ an outside party to do that for you?
Well, CPA firms would do that. 338 advisors offering fiduciary sort of audit could do that. I think it's 338 and the CPA firms. I think they're best positioned to provide that audit.
Well, very good. Well, Gus, thank you for the high-level overview here on 401ks, and for Jim and Tammy on other areas where we have personal exposure. I am going to send out the slides and Gus's Jim's and Tammy's contact information to you. And if you want to share this information with others in your firm or colleagues that you have, please feel free to do so. And also very much welcome you to reach out to Gus, Jim, and Tammy with any other questions you may have. I know they would be very happy to help provide education and make sure your questions are answered. So thank you very much for your time here today, and wish you all a very good day. Goodbye.
Thank you for having us. All right. Bye-bye.
Bye-bye.